of the Chhattisgarh Land Revenue Code for correction of the wrong entry made into the revenue records. It was alleged, my lord, in the application that khasra number 1035, Rakba 1036 acre belongs to the petitioner's father, my lord. And the uncles of the petitioner were sold, my lord, the land to the respondent 1735 Rakba 0.36 decimal.
So what is the error?
Error is this, my lord. The my lord will please to see, my lord, the order passed by Tahsildar, P2, my lord, page 19.
Page 19. That is not on merits.
But this was the on merit, my lord. P2, Tahsildar.
The dispute, the pending, in fact, issue which is involved in this repetition is the allowing or rejecting of the delay application. The appeal is filed after 51 years.
My lord,
what is the justification granted?
My lord, the Tahsildar had allowed my application, my lord, order that the wrong entry may be corrected, my lord. My name may be recorded into the revenue records. Against which, my lord, the respondent preferred an appeal before the SDO. SDO said, my lord, that the amendments revenue records cannot be done by Tahsildar itself, my lord. My lord, may kindly see the order passed by Tahsildar, my lord. SDO, P2, my lord, page 25.
Page 25.
ये 24 से ही शुरू करता हूँ प्रकरण में संलग्न लास्ट पैरा प्रकरण में संलग्न
just a minute. This is of different proceeding.
But the same proceedings.
The SDO order is at page number P5, page number 35, of which the Board of Revenue is passed an order.
But the proceeding
to page number 35.
P5, Anubhagi Adhikari.
By this, the application under section 5 was allowed.
But this appeal was filed, my lord, in pursuance of the order passed by the SDO. That is on page number, my lord, 19.
No, therefore, the challenge in this appeal is to the order dated 3/3/1968.
That was not the order, my lord. It's an entry, my lord, made into the revenue records. And that's what, my lord, the Tahsildar had said. That the entry made into the revenue records, who had made that entry is not known. But the SDO said, my lord, that it must be done by the Tahsildar, and the Tahsildar cannot review its own order. Therefore, my lord, the petitioner had to file an appeal challenging the entry into the
Therefore,
revenue.
you are not aggrieved with the entry since
No,
last 51 years.
My lord, I
Because
know.
Since formation of the Chhattisgarh also,
My lord,
based on the revenue entries, paddies, etc. are being sold.
my lord,
The agriculturers get
my lord,
the loan, etc., the agricultural loan, etc., based on the revenue records.
my
So you yourself are not
lord, up to
aware with respect to what are the revenue entries
my lord, up to 2000
of your land you are holding, of your land, if any, you are holding.
My lord, up to 2016, my lord, my name were recorded into the revenue records.
So
Up to 2016, my lord, it is in the record also. My lord.
it says only one entry of 2014, rightly or wrongly.
My lord, in Tahsildar's order, my lord.
Therefore, it has the courts have taken cognizance of the entry dated 3/3/1968,
My lord,
and you are challenging based on some observation made by the sub-regional officer
my lord,
of the entry dated 3/3/1968.
my lord.
So you can't say that there is your name is recorded up to 2016 in the revenue records.
My lord, in the order passed by Tahsildar, my lord, it is mentioned specifically that in B1 and all the revenue records, my name were recorded up to 2016.
कहाँ पर है?
My lord, that is on page number 19.
तो फिर वो entry को क्यों challenge करना है जब?
That
So there is an entry.
My lord, this is the entry itself, my lord. It could not be, my lord.
वो है ही नहीं.
वो entry भी देखेंगे. It is on page number 34, my lord. तीन 368 आदेश और ये सूचना देने के बावजूद संशोधन किया गया. Who had, my lord, passed the order, original order? It is not in the report. And that's why, my lord, the तहसीलदार said कि किसने किया वो मालूम नहीं है और अवैधानिक एंट्री है.
ये जो बॉटम में पेज नंबर 33 में क्या दस्तखत है?
पेज नंबर 33 में.
पेज नंबर 33 में है ना?
जैता बैनामा के
आदेश भी है ऊपर में. बॉटम में अलग एंट्री है.
जैता सूचना पाने के बावजूद अनुपस्थित संशोधन.
There is a signature of the revenue official also.
This is what, my lord, the तहसीलदार said. Who had put his signature?
नहीं, तहसीलदार 68 का भी तो ये नहीं बोल सकता ना अभी का तहसीलदार. ये नहीं है कि अभी भी 2 साल पहले का है तो पुराना तहसीलदार है, उसको मालूम है कि किसकी दस्तखत है क्या नहीं है.
पर ये it is not in the record.
भाई, you have produced a copy. It is the photocopy of the original record, which bears some entries, and it is to be proved where you are aware. इसको कैसे सिद्ध किया जा सकता है?
My humble submission would be, my lord, once, my lord, the SDO and the collector condone the delay, my lord.
कहाँ कलेक्टर SDO ने क्या डिले किया है? SDO has not made any observation. सद्भाविक प्रतीक होता है क्या? सद्भाविक no observation made. He is condoning the delay since of 51 years.
But that was upheld by the collector also, my lord.
So it is to be considered. It is to be reasoned out. It is not a case of delay of 1 year, 2 year. Which is your application for condonation of delay?
My lord, that is on page number.
आपने कोई एक पिटीशन लगा दिया, बोले कि SDO ने ऐसा किया इसलिए हम नहीं लगा रहे हैं.
That was filed, my lord, under the pressure of the order.
So it is to be understood.
My lord, application is at page number 26.
Page number
26.
26. पढ़िए क्या है?
It is on page number 28, my lord. Appeal है 26 पे.
2019 को अपील जानकारी सामग्री के अंतर्गत है. 2000. The advocate who filed the appeal before sub-judicial officer has to be given certificate.
It was made, my lord. All the mistakes were done by, my lord.
No.
Under the pressure of the. But
because rights of the parties are also to be kept in mind. अब 51 साल पुराने केस है, and you are but just moving an application and taking an observation some officer and making a ground that it is the proper ground for condonation of delay of 51 years.
But my lord would kindly appreciate, my lord.
That ground delay can be condoned, but there should be reasonable ground, sufficient ground. So and so for the petitioner, so and so for the.
But if my lord will please to, my lord, consider that the land, my lord, which was purchased is 0.36 decimal, and he's claiming, my lord, 0.36 acre. Lord, there are lots of difference, my lord.
No, to see, I'm not saying claiming. कब claim कर रहे हैं?
हाँ वो
भाई अभी तो claim नहीं कर रहे हैं.
हाँ.
It means you are not in possession of that portion of land since then. If they claim based on some sale deed or some revenue entries, you might have a ground that now they are claiming. And because of now they are claiming of the land which has been executed, sale deed of which is executed about 50 years back. and therefore you have a right to file an appeal, revision, etc.
My only submission would be, my lord,
Because in the garb of revenue entries, you cannot nullify the sale deed, registered sale deed.
my lord, that's what my humble submission is, my lord. If my lord,
अगर registered sale deed में जितनी entry है, वो land का mention है, you have to challenge the sale deed. Take recourse to the civil law. So and so forth the petition. Therefore, I say the advocate has to be given a certificate to making out a case. So and so forth the petitioner, so and so forth the respondent. Petitioner has filed this writ petition challenging the order dated 3/7/2024 passed by Board of Revenue Chhattisgarh Bilaspur answer P1, whereby the revision filed by the petitioner was dismissed. Counsel for petitioner submits that the petitioner that the land bearing Khasra number 1035, measuring 0.36 acres, situated at village Rajja, Tehsil and district Sakti, was ancestral property of petitioner, which father of the petitioner got in partition. The name of the petitioner was recorded in the said land up till 2016 in the resident pustika and the irrigation paper. Respondent number 1 purchased the land bearing Khasra number 1735, measuring 0.36 decimal from ancestors of the petitioner, but respondent number 1 mutated his name against Khasra number 1035, measuring 0.36 acres. The petitioner therefore filed an application before Tehsildar Sakti under section 115 and 116 of the Chhattisgarh Revenue Code to correct the wrong entry in the land records. The Tehsildar, by its order dated 16/9/2019, has allowed the application, corrected the revenue interest by deleting the name of the respondent number 1. Respondent number 1 thereafter filed an appeal under section 44(1) of the Chhattisgarh Land Revenue Code challenging the order of the Tehsildar, and the appellate authority held that once the revenue entry made in 3/3/1968 by the Tehsildar, the Tehsildar, and therefore passing an order correcting the revenue entries is not within the jurisdiction of the Tehsildar, as it will amount to review of its own order, and allowed the appeal by order dated 2/12/2019. He contended that it is thereafter the petitioner has filed an appeal before the board of before the sub-divisional officer challenging the revenue entry dated 3/3 challenging and seeking correction of the revenue entry dated 3/3/1968. Of the revenue entry dated so, along with an application for condonation of delay. ये अपील कब फाइल हुई है? तारीख है? The Board of Revenue, considering the readings made in the application as also the appeal, has allowed the application under section 5 of the Limitation Act and condoned the delay. The order condoning the delay was put to challenge in a revision before the collector, and the revisional authority, after considering the arguments raised by both the sides, have dismissed the revision. The order of collector dated N12/2021 is further put to challenge before the commissioner, and the commissioner, without considering the facts and circumstances of the case, nature of grounds raised, has allowed the revision and set aside the order passed by the sub-division officer as also the collector. And held that the appeal was barred by limitation. Petitioner thereafter has preferred the revision before the Board of Revenue, and the Board of Revenue also dismissed the revision without considering the fact pleadings made therein, pleading made in the revision grounds raised, and the submission made by counsel for the petitioner in an appropriate manner. He contended that as the revenue entries, the name of the petitioner is recorded in the revenue reports up till 2016, and therefore the learned commissioner and the Board of Revenue heard in coming to the conclusion that the Board of Revenue has condoned the delay without ascertaining condoned the delay without considering that whether the sufficient explanation is made for condoning the delay or not. So and so forth, the state opposes the submission and would submit that